This is the Rocket City Retirement Show with Cris Wallace. Cris loves educating people in person and over the airwaves. Whether it's retirement planning, investing, tax, or legacy, Cris prides himself in helping protect what matters to you. This is the Rocket City Retirement Show.
Hi, I'm Lou Ann Fulmer, and welcome to the Rocket City Retirement Show with certified financial planner Cris Wallace. He's president at WG Financial Group. Also joining us is certified financial planner Richard Constantine of WG Financial Group. And we are so excited that we have a guest today. Doug Martinson is joining us. He's an attorney here in Huntsville. He is a senior partner at Martinson and Beeson. He has a finance degree from Alabama and a law degree from Washington and Lee. This is kind of cool. Doug Martinson II, born and raised right here in Huntsville. He's a third generation graduate of Huntsville High School. And since 1990, when he joined Martinson and Beeson PC, he's been a leader in the Huntsville community, and his practice focuses on estate planning and probate and wills and trust, guardianship and elder law, as well as corporate and business planning and disputes. And with that, we're going to be talking about the E in Chris's process, the Rite Retirement process, and that's estate planning. Doug, we want to welcome you to our show.
Well, thank you. It's good to be here.
So excited to get started. So let's just kind of talk. First of all, Doug, tell us what your day-to-day life is like as an attorney right here in Huntsville.
Well, right. So I'm fortunate to be working with my son now, and I was fortunate to work with my dad, and he worked with my grandfather. So it's always good to go to work and see them and then see our clients. And so a lot of times we'll be meeting with clients throughout the day, talking about their estate plans, going over their finances, seeing who they want to appoint to be in charge of their assets and what they want to do them when they die. And then also we handle a lot of probate and estate, and then also the guardianship and conservatorship when people haven't done the proper planning to get the documents in place so that they can name who they want to be in charge of their affairs if they become incapacitated and when they die.
So you guys have a very, very busy schedule, don't you?
Oh, yes.
Okay, so let me just kind of review to our audience what we have been doing here recently. Cris has a process that he takes retirees through, and it's called the Rite Retirement process. It's an acronym, Rite, R-I-T-E. I always tease him. He spells Rite incorrectly, but that's not true because it's an acronym. R-I-T-E. The R is for retirement income, and then the I is for investments, and the T is for tax strategies, and then the E is for estate planning. And that's what we're going to focus on today, estate planning with our guest, Doug Martinson. And so my first question for you, Doug, is estate planning for everyone?
Yes, it is. A lot of times when I was a younger attorney and had friends who were younger, and they say, well, I don't really have an estate, so I don't really need a will. And I said, well, you're married? Yes. Do you have children? Yes. Do you have insurance or policies at your office? Yes. Or your workplace? You have retirement and you have a house. So you really need to set up an estate so that if something happens to you, you can name guardian for your minor children. You can name trustees to manage the affairs so that if something tragically happens to you, that it'll save time and money and also stress. So estate planning is for pretty much anyone, and everyone needs it. And of course, later in life, you could use the estate planning to pass on generational wealth or pass your assets down to your children or grandchildren or charities or whoever you want to.
So, Doug, I have a question for you. So, when we met a few weeks ago, actually, and, I am currently engaged. I asked you specifically, what is the benefit of obtaining a will if I don't own any properties? Because I know that all my investment accounts are already beneficiaried out to my fiance. But what happens if I don't have a will for other assets? And you brought up a point, and please correct me if I'm wrong, but you brought up a point that in the state of Alabama, your spouse is only entitled to the first $100,000, and then it goes elsewhere. Is that correct?
That's correct. So if your parents are surviving, they would actually split the assets with your spouse. Now, if you have children with them, then it goes to the children, and your spouse would get would get more of it. But yes, if you don't have a will, then the laws of Alabama, the intestate laws, would determine who it goes to. So it's very important to have a will for any non-probate assets.
So, Richard, I have a question for you. You've already marked your fiance as the beneficiary.
I have. Yeah, she's a lucky woman.
Yeah, well, you better make her test your coffee or, take a bite of your food before you do first. All right. That's just a little tip there for you.
If we're starting off on that foot, then I picked really wrong. So
you may not know it. So anyway, all right.
I don't have much right now. So,
all right. So Doug, got a question for you as well. Are there certain documents that every family has? And the reason I asked this question, I would say that probably, and I'm swagging a number here, as a lot of my clients like to say, the swag number. I'm going to swag this number, but about 40% of individuals and families that come into the office, they have no legal documents whatsoever. So are there certain documents that you feel like as an attorney, every family or individual should have?
Yes, and I would say that 40% is maybe even low, because there's a lot of people that don't have wills, and they don't have them for various reasons. A lot of people don't want to talk about death or just put it off. But yeah, so the most documents you should have is a power of attorney, and it's a durable power of attorney where you can appoint someone to be able to pay your bills and manage your affairs. And this could be if you were out of town or if you became incapacitated. Most of the time it's used for when you're incapacitated. So it prevents having to go to court to get a conservatorship or a guardianship to make decisions for the person. So a power of attorney is important to do. And some people don't want to give up the authority or delegate their control over to someone. So there are some limited power of attorneys. There's a springing power of attorney that doesn't spring into action unless you're declared incapacitated. And there's also limited to scope. If somebody's going to be out of town and you're selling the house, you can give a power of attorney to someone to execute the documents. But the power of attorneys can be very important because it can save a lot of strife and a lot of legal fees if you have to go to court to get a conservatorship. The other one is a power for health care. So you can name someone to be your health care power of attorney to make decisions for medical decisions to doctors, and also can make end-of-life decisions. A healthcare power of attorney doesn't come into play unless you're incapacitated. So if you're able to communicate with the doctors or the medical profession regarding your care, they will allow you to make those decisions. But if you're unable to, you can appoint a spouse, a child, or a friend to make those decisions in a healthcare power of attorney. The other is an advance directive for healthcare, also known as a living will. And that's where you can state whether or not you want to be hooked up to life support in the event that you're terminally ill or injured, or that you're permanently unconscious. So if you are not going to get any better, the physicians have observed you long enough to make that determination, you can state that, yes, I do want to be hooked up and I want to stay alive as long as possible. Or if I don't see any hope and the doctors don't see any hope, I would like that to be removed. And you can also put that you don't want to be hooked up to a feeding tube in addition to that. And then the last one are the last will and testament. And that's where you can appoint someone to be your executor. And you can also appoint an alternate executor in case something happens to them. And then you say who you want your property to go to. And if you have minor children or special needs children, you would probably want to put that in trust. Or if you had other children that you just want to make sure that that money is going to be there for a while or it's protected from creditors, you can put it into a trust. But those are the 4 documents that most people talk about in estate planning.
Okay, question on the power of attorney. So durable, if I'm understanding this correctly, and I'll make sure it's super clear to the listener as well. If it's durable, it means it's enforced from day one. So that person that you're given that power to can literally go and transact if they were that, were you, right?
Yes, that's correct. There are some legal protections where they can't just go and use that, for their own personal use.
Well, that's good. I did see my sons walking into my bank the other day, so that was a little bit alarming. Right. So this is really good to know. So got to have another question for you. The power of attorney and the power for healthcare, can those be in the same document, or are they 2 separate documents?
We usually get two separate documents. So we have the healthcare power of attorney that's separate, that would really only be used for in medical purposes.
Okay.
And so they would go to the doctor to give those. And then the durable power of attorney is for finances. And so that's the one that they would show to the financial advisor or the bank or insurance company to make decisions, and also the IRS to make decisions on, or can file income taxes, hire accountants, et cetera.
Okay. Good. That's a great explanation of those documents. I think that, even for me, that cleared up a couple of things myself.
Yeah. No, thank you, Doug. Question, and I've seen this a lot with especially younger families. They ask about the ability to do the documents online. What are your thoughts on that?
Right. Well, there's a lot of issues that we've had with people who've done their documents online because, these are state-specific documents. So Alabama has its own laws versus Mississippi. So the laws are different. Also, there's some things that may not be in those documents that may cost your family more money. A lot of times they don't waive a bond or an inventory. So a bond could be very expensive. That comes out of the estate. It's where the executor has to be bonded. So a lot of times you see the documents online not waive the bond. So that can cost money. And then a lot of times people, when they draft it, what they think is written clearly isn't. And they may not know the difference between what per stirpes is, where you can leave it to your children, and if they predecease, to your grandchildren. So there's a lot of different language in there that the online documents or the people preparing them may not know. And we've come into several cases that, where people have done the documents online. They're not well drafted. They're also not executed properly, because in Alabama, you have to have two witnesses and a notary to be self-proving. But for it to be valid, you have to have two witnesses. So I've had several people come in and say, we have a will and it's notarized. Well, the note that it's not a will in Alabama, because it only has one witness who's the notary, and you have to have two witnesses. So even though they go to the bank and the bank notarizes it, it's not a valid will. In some cases, they're the stepchild, or they're somebody that would not take under intestate laws, and you have to say, I'm sorry, but you're not able to to take under this will.
I want to take a moment to give out our phone number. Please, we want to make sure that you have this number. If you have any questions, you certainly can call 256-937-2010. You can go in and talk to Chris and his team about estate planning. And then, of course, any specific questions you have, you can get answered. So 256-937-2010, that's the phone number. And WGFinancialGroup.com is our website. You've joined the Rocket City Retirement Show. We're so happy you joined us today. I'm Luann Fulmer. I'm talking with Cris Wallace, president of WG Financial Group. Also, Richard Constantine joining us of WG Financial Group. And our special guest, Doug Martinson. Doug Martinson is senior partner at Martinson & Beeson right here in Huntsville. We're having a great conversation about estate planning, which happens to be part of the plan that Chris and his team will take you through. When you come in, have a written retirement plan, it includes estate planning.
Yeah, so I do want to make something super clear here, Luann, as we're talking about estate planning, because Doug's on the show. We do estate and legacy planning, but we don't actually do the legal. So when we walk a family through the process, as a certified financial planner, I do make them aware if there's any potential issues that I sense as a planner, and then of course I refer them out to professionals such as Doug. So I want to make sure the listener knows that we don't do wills, we don't do trusts, we don't do POAs or things like that. We do some legacy planning, but it is part of the estate and legacy review part of our process that we do. So I just want to make sure that's like super clear to the listener, and for compliance reasons as well.
Yeah, that's a good point. It's just that's part of your plan, estate planning, and the other part is the retirement income, retirement investments, and retirement tax strategies. And then we're talking about the estate planning today.
Correct. And real quick, just on that note, we were talking about doing documents online. From what I gathered from Doug and what he was, how he was answering that, is there's some risk in doing it online. And I think there's a lot of do-it-yourselfers out there that They don't want to pay anybody, and they have the money to do it, right? I mean, some of the people that I've run into that want to do things themselves, they have a massive net worth. And I'm thinking, why would you not just pay a professional to come alongside you and just do what they do every day? I mean, it makes no sense to me, because you're potentially putting your family at risk in terms of your estate by not hiring someone who does it for a living. So anyway, I just thought I would throw that in there.
All right, let's go to this is a question that I wanted to ask you, Doug. What do you think about these celebrities who are advertising legal services online?
Are you real quick, Luann, are you asking like these people that say, oh, you can go and order your legal package from my website?
Right.
And yeah, I don't want to name any names because I don't want to offend anybody, but there are celebrities out there that, oh, you can go to my website and download these legal documents. So yeah, Doug, great question, Luann. I just want to make sure I was clear on that as well.
Yeah.
All right. I think, you have to be aware that the celebrities are being paid, and they most likely are not using those services. And you have to be very careful about using them. A lot of times they're pushing the reverse mortgages, which in a lot of cases, in most cases, is not a good deal. So you really have to be careful about, what you see endorsed on TV, to where, if you hire a local professional, they're not going to have all that advertising cost. So it's probably cheaper to do it, and certainly would be better to, have somebody in your local community who knows the local state laws to handle your legal services.
So Doug, you don't think Tom Brady and Steph Curry eat Subway every day?
Right.
Okay.
Doesn't look like it.
I don't think so. I mean, Jared did. And look, Tom Brady, and look what happened to Tom Brady and Steph Curry. Jared made Tom Brady and Steph Curry.
Who knows? So Doug, we've talked about doing the online documents. What about people who decide to handwrite a will in the state of Alabama?
Right. And that's a good question, because in Alabama, a holographic will, or one that's in your handwriting, is not valid unless it has two witnesses. So in Mississippi and in Virginia, where I went to law school, you can have a handwritten will. So if you are sick, or you're in your house, or you're dying and you write a will out, that would be valid. But in Alabama, it's not valid. It has to be witnessed by two people. And so we've had that come up where people say, well, here's my will. And we're like, well, he signed it. It's in his handwriting. There's no doubt this is what he wanted to do, but there's not the two witnesses.
Wow. So let me so first of all, I did not know this. And Chris didn't know this. No, he did not. This is why he hires an estate planner to do his documents. So in the state of Alabama, it doesn't even have to be notarized. It literally can just be two witnesses. So you could have the neighbor on your right and the neighbor on your left sign the will, and that's good enough?
Yes. Now, they do need to be present at the time you sign it, or they need to request them to sign it. We did have a will contest one time where the will looked perfect. What happened, the guy actually took somebody else's will, typed it up to save, at the time, probably $400 or $500, but wanted to exclude his daughters and give it to his sister. So he typed it up, and it had the notary, and it had all the lines, and all the witnesses were there, and it was notarized. It looked like a perfect will. Well, when they contested it, they asked the witness, well, where were you when he signed it? Well, he hadn't signed it yet. So you mean you signed a document with no signature on it? Yes. So he didn't see him sign it. So it threw the will out, and everything went to the daughters who he didn't want to leave it to. So if you have a handwritten will, it's not valid unless you have the two witnesses and they're there.
Okay. So that brings me to another question. If a will has to be probated, right? When somebody passes away, the will has to be probated. Is that correct?
If they're probate assets. If there are no probate assets, if everything was joint tenants with survivorship, or they had beneficiaries, then it would not have to be probated. But if there are assets that are just in the decedent's name, then it would have to be probated, or the state would.
And if that will is being probated, that will can literally be contested by anyone?
Well, it could be contested by any interested party or heir at law. So if someone would take or receive assets from the estate if they died without a will or intestate, then they could contest it. And they have 6 months, and there are certain grounds they can contest it on. If it wasn't executed properly, like the example I gave where the witnesses signed before he did, if the testator signature was forged, or if he was unduly influenced, if somebody basically said, I'm going to put you in a nursing home if you don't sign it, or lied or get them to do something to induce them to write the will, or if they were incapacitated and didn't understand what a will is and what who their relatives are.
Okay. So I think I understood you to say just a few sentences back that if you have your accounts beneficiaried out, like joint tenants or your bank accounts, IRA, 401k, then those assets wouldn't be in the will, right?
Right.
And
they would not be a state asset. So they would pass to whomever was listed. So if you had a bank account at Regions, and then you put in and you had a beneficiary, a pay on death, or a joint tenants with survivorship on it. And even if you said in your will, I leave my Regions bank account to thy church, it would go to whoever's listed on the account and not what's listed in the will.
Okay. So I think just to kind of sum this little section up right here, it sounds to me, and this is what I usually tell people, is a named beneficiary is going to trump the will. So for example, if you have your son's name as a named beneficiary, but the daughter's name in the will, and you really didn't want it to go to the son, but he's the named beneficiary, it's going to the son.
Yes, that's correct.
Okay. Is there any way to contest that?
No, because it's basically a non-probate asset. So unless they said that wasn't his signature or at the bank, but that was very hard to do.
Right.
I do want to point out when you mentioned about having a notary. So everybody, there's basically a will is notarized when it's a self-proving will. And so a self-proving will is where you have two witnesses who sign, and a notary writes a statement that the testator is over the age of 19, of sound mind, and not unduly influenced, and sign the will in front of the two witnesses. And so when you're probating the will, it makes it a lot easier because you don't have to go prove those facts because it's in that statement. So when at your death, when it's being probated, you don't have to have a hearing if everybody signs off on it. And even if somebody didn't sign off on it and wanted to contest it, the will would still be admitted to probate, and then they would have to bring their contest after that.
Mm-hmm. Okay, I want to make a couple points for her because this is actually really, really, really good stuff right here. So number one, if you're listening to the show, check your beneficiaries, make sure they're updated, make sure you've got the right people that you want that asset going to or those assets going to, especially if you're recently divorced, because we've seen it before where there's been a divorce and you think you've updated everything and you haven't. So you want to go and make sure that those assets are beneficiaried out properly, because that named beneficiary on file is going to trump the will. So no matter what you have in the will, the named beneficiary is going to trump it. And secondly, he mentioned the bank account. Many families listening today do not have a named beneficiary on their checking and savings accounts. It's not required when you open the checking account. Most of the time, they don't ask you for that. So the next time you go into the bank, ask your teller, do you have POD on file? POD means payable on death. That is the bank's language for beneficiary. Again, most checking and savings don't have a POD on file. Now, why is that important? If you pass away with that account is going to have to go through the probate process. There's no point in having that happen when you can literally put POD on file. So it's really important for everybody listening to the show. And Richard, I think you have something you wanted to add to that.
Oh yeah, no, and it's funny that you mentioned that today, Chris, about if you get a divorce, making sure that you update your beneficiaries.
You guys are already divorcing? You just put her down as a beneficiary.
No. I met with a prospective client this morning, actually, and we were going through his TSP and his insurance policies through work. And keep in mind, they got a divorce over 2 years ago. His ex-wife is the beneficiary on both of the insurance policy and the TSP. And so, like Chris said, it's just important to make sure that you are reviewing how your accounts are going to be titled. And as Doug said, if they are beneficiaried out, there's no stopping that from being executed.
Gotcha. And Doug, I think you touched, I'll kind of ask maybe one of our next questions here is, and I think you touched on this, but what happens if you die? Can you just touch on again what happens if you die without a will in the state of Alabama?
Sure. Yeah. So if you die without a will, you'd have to, and had assets that are probated. The only way to get those assets to the heirs at law would be to file an administration of the estate. An administration is a lot more expensive because the administrator has to be bonded. So if the estate, is $1 million, you may be paying $5,000 for a bond premium. Also, the administrator has to live in the state of Alabama. So if you have your children and they live in Tennessee or they live in Minnesota or wherever, they cannot be the administrator at Alabama. So they'll have to find somebody here. And then, so there has to be an inventory filed. So the court it'll be public record of what your assets are, that you have a bank account, how much is in it, you have a stock account, or you have retirement account. All of that has to be listed and filed for public record. And then you have to, of course, you still have to advertise in the newspaper and notify the creditors, but it's just a lot more expensive to do. Also, if you have a house, you can't just go and sell it. So the will, you can appoint an executor and give them the power to sell the house or the public or private auction without court approval. But if you don't have that court approval or you don't have a will, you have to go to the court and have a hearing to approve you selling the house or any property, including a car. So you may be going to the court to have an estate sale to sell any of this property. Also, if you have a minor, they're going to have an attorney appointed or a guardian ad litem to go to every court hearing to make sure that everything's done in that minor's best interest. And that runs up the cost. And then if you have minor children, it would have to go to a conservatorship. And the bad thing is that they're going to get everything at age 19, which, is quite young for somebody to get, a large amount of money or any money that may be blown or wasted. So if you die without a will, it really costs your heirs a good bit of money. And it's going to go according to the laws of the state of Alabama, whether or not you wanted to cut a child out or cut a brother or relative or cousin out.
Yeah. So I think just to kind of summarize that, there's a couple of key points here. Number one, don't die without a will. Like, just go get it done, knock it out. That's number one. Number two, if you don't care and you want the state of Alabama to decide where the assets go, then die without a will, and most people don't want to do that. So, like I said, we've met with a lot of people that come in the office. It's one of the questions that we ask. We just kind of poke around and ask questions. Do they have their legal in place? Because we feel like we owe them that as financial planners to ask those questions and then be able to point them in the right direction to be able to go sit down with a professional who can actually do those documents for them. And I think a lot of times every family is a little bit different in their wishes. There are certain things that some people want in their wills and other people don't want it. So that's why, we refer those prospects out. We have them sit down with professionals and we tell them just to be very open and honest when you're trying to do all of those documents, because I can tell you when we did ours, it was a lot of information. And frankly, I didn't want to do it. My wife ended up having to pin me down and say, Chris, we have to answer these questions. We must do this. Our appointment is 2 days from now, and you've waited this long. It's hard to talk about dying, but that is part of what we owe our heirs, is to make sure that our proper legal documents are in place. So we are about halfway through the show. So this has been phenomenal so far. Can't wait to get into the rest of it. If you're listening right now and you want to catch the whole episode, just make sure you hop out to Apple Podcasts and Spotify, and you can listen to the second half of the show.
Don't panic in uncertain market times. Let Cris Wallace be your trusted guide. Call Cris Wallace today at 256-937-2010 for expert advice and support. That's 256-937-2010.
Wait. Now, wait a little longer. Great. You may have just increased your lifetime income by tens of thousands of dollars. That's how Social Security can work for you. The longer you wait, the more money you may get. Deciding when to start taking your Social Security benefits is one of the most important retirement decisions you'll make. Cris Wallace and the team at WG Financial Group can show you the options and help make the right decision for you and your situation. Call them today, 256-937-2010. You spent decades paying in. Optimize what comes out. Cris Wallace and the WG Financial Group team can help you squeeze every penny out of your Social Security benefits. Don't wait any longer. Call now, 256-937-2010. That's 256-937-2010. Investment advisory services made available through AE Wealth Management, LLC, a registered investment advisor. Firm is not affiliated with the U.S. government.
Want to feel confident in your financial future? Let Cris Wallace from WG Financial be your guide. Take the first step today by visiting WGFinancialGroup.com.
We thank you so much for joining us. This is the Rocket City Retirement Show. I'm Lou Ann Fulmer here with Cris Wallace of WG Financial Group, also Richard Constantine, WG Financial Group. And our special guest today is Doug Martinson. He's the local attorney, a local attorney right here in Huntsville. I should say the local attorney, right? But he's senior partner at Martinson and Beeson. And so we're so excited to have him here today because we are talking about estate planning, just the basics of that and how we deal with that in retirement planning. And Doug, that is what your company deals with, estate planning and probate and wills and trusts. So this is great information here. And so my question to you would be, let's say that I own out-of-state property, maybe a home or something like that. What are some things that need to be considered for my estate planning with that in mind?
Right, and that's a good question because we're here in North Alabama, so a lot of people have a farm in Tennessee, or they may have a condo at the beach in Florida. And so, if you have those assets out of state, you actually have to do a probate in the state where you died and your residence of. So, let's just say you're in Huntsville, and you have to probate it here, and then you have to probate an ancillary estate in the state of Florida, and that's basically getting certified or apostolated copies of the documents and then probating it in Florida. So that can run into a lot of cost, extra cost, because you're basically doing two probates, or depending on how many states your properties are in.
So as far as the Alabama, the probate, let's just say cost, from what I hear, it's not awful. Would you say that's fairly accurate statement?
Yes.
All right. Do you happen to know anything about Alabama versus the state of Florida in terms of cost?
Right. Yeah, that's a good question because Tennessee and Florida and several other states have a percentage that can be charged as an attorney's fee. So there actually is a schedule to where there's a percent or of the estate that's going to be paid to the attorney as an attorney fees. And then some states like California have a probate tax. So if you have assets, you may be paying $30,000, $40,000 in taxes to the state of Florida, to California. But and so there are ways around that. That's really how the revocable living trust, or revocable trust came about. But yes, that's a good question because each state has different fees and expenses. While Alabama, it's not that bad. The other states are, can be expensive.
So how do you say it? Do you say revocable or do you say revocable?
I usually say revocable.
That's what I say. I'm from Georgia. It's revocable. Right. That's how I say it. So anyway, so that was kind of funny. So that's good stuff on the out-of-state stuff. I think a lot of people, you're right. Here in Huntsville, they own property either just over the border in Tennessee or down on the Panhandle in Florida, 30A. And the fact that you're going to be probating in two states not only is cost involved, it's kind of aggravation as well, and also some time. So good stuff. Thank you for sharing that.
Yes. Yeah, so Doug, you mentioned a revocable trust. What is it and why is that beneficial to actually establish with property out of state, and also if you don't own property out of state?
Right. So the main reason for a revocable trust is to avoid probate. And there'd be a lot of reasons and situations to avoid probate, just like we talked about with out-of-state property. But let's say you have an out-of-state, your children are out-of-state, and that you want them to be the executors. And they may be in the military, they may be doctors, they may be financial planners, they may be busy and can't really come down to Alabama to probate it. So if you set up a revocable trust, you can name whoever you want to be the successor trustee. And then at your death, that property's already in the trust, and that's where their beneficial interest takes place. So basically, a trust is set up where you would set the trust up, then you would transfer your property to the trust. So you would deed the property. So if you are in Alabama, we would prepare a deed to your house or other investment property to the trust, and then it would be owned by the trust under your control. And if you had property in Tennessee or Florida, you could get an attorney there to transfer the property to the trust. And then when at your death, your kids or whoever's the successor trustees can come in immediately and be able to sell it without having to go through probate and without having to have the cost of probate. So these are very beneficial, and especially if you have minor children, because like I said earlier, if you probate a will and you have minor children, they're going to have an attorney appointed to represent them, guardian ad litem, that can run the cost up. So the revocable trust are really a very useful tool.
So
ahead,
one thing
Richard.
that you mentioned, Doug, was that these documents are state specific. So if you, for this example, if you have the house, you're from Huntsville, you have the house in Florida, but then you also have a winter house out in Colorado. You wanted to go the revocable trust route, can you put everything into one trust, or do you have to get 3 different trusts created for Alabama, Florida, and Colorado?
All right, that's a good question, because you actually could have that Alabama trust own property in Colorado. So basically what would happen is you would give the name of the trust to the attorney in Colorado who's going to prepare the deed, and the deed to that property would be deeded to the trust. And then when it's going to be sold, then the Colorado attorney or whoever's doing the closing would get a certification that the trust was set up in Alabama, that it was owned by the trust, and who the trustees are.
Okay, so talking about trust, I think I've run into this multiple times. So someone comes in, they're trying to kind of feel their way through the whole legal estate process, and some questions I can answer on the basic side. A lot of them I defer out to the attorney. But I think the misconception is that a trust, a revocable living trust, we call it revocable living trust, that protects you from what people would know as the Medicaid spend down, where you have to spend all your assets down to go into a nursing home. Does a revocable living trust protect you from Medicaid?
Right. That's a good question, because a lot of people, when these first came out, would say, oh, it protects me from Medicaid and it protects me from the estate tax. And it does not do either one of those. And really, in the Medicaid planning, you really have to give away all your assets. So a lot of times I'll have people come in and their net worth's $1 million and they want to do Medicaid planning. It's like, well, you don't want to give away all your property now. I mean, unless you want to go travel or spend it, that's a good idea. But don't give all your property away to your children now, so you can go live in a Medicaid facility, which won't be as nice as what you're used to. So, right, the revocable trust does not protect it from Medicaid or the estate tax. Of course, now the estate tax is for $13.61 million. So, that's not as big a deal as it used to be when the estate exemption was $600,000 when I first started out.
Mm-hmm. Yeah, and it's actually because of portability, it's up right at 27 at this point.
Right, for each person. Right, so the spouses can get that times 2.
Yeah. So what I understand happens, and again, this is for clarity for everyone, and maybe a little clarity on my part. You have a revocable trust, and let's just say, I'm going to keep it really simple. You have the house going to the son, and you have, let's say, you have a son and a daughter, and so the trust says that's where the house goes. Once you pass away with a revocable living trust, essentially, when you die, that revocable living trust turns into kind of an irrevocable trust at that point, where the trustee has to administer the wishes in the trust as they were written. They're kind of locked in. Is that an accurate statement, or is there a better way to explain that?
Right. No, that's accurate. So, once you die, that trust can't be changed, and it's irrevocable, other than transferring that house out to the son or whoever's left to.
Okay.
So, Doug, does everybody need a trust, or are trusts just for the wealthy?
Right. Well, really the wealth doesn't have so much to do with whether to get a trust, now, since with the estate tax exemption being so high. But really, so the most of the time it's for somebody who wants to avoid probate. Sometimes they may want to leave a child out. They may have a second family. They want to leave the children by the first family out, and the family may not have, those children may not have anything to do with the decedent. So if they die with the will, they have to notify those children, and that gives them a venue where they can come in and not sign waivers and cause delays. Whereas a trust, it's just automatic. It just, once they die, the successor trustee takes over and they don't have to notify anyone.
Mm-hmm. So what I hear you saying is it's, in terms of does everybody need a trust? Is it just for the wealthy? It's more wishes, not wealth.
Right, exactly. In each situation, if you have the out-of-state property or minor children or out-of-state executors, and it really makes it a lot easier for whoever you're leaving the property to or whoever's in charge as the executors or the successor trustee, because they won't have to come in and go to court to get appointed. They won't have to wait 6 months, notify creditors, and then be kind of tied up for, a half a year or more.
Okay. Yeah, no, that's good stuff. I think that's very confusing when we start talking about trust with people. I think it can be very, very confusing. And this has been an excellent portion of the show for sure. So do you, in terms of, we were talking about probate earlier. So in terms of probate, do you have any idea on average, I don't know if you have statistics or you just kind of know this off the top of your head. Do you know about how long it takes to go through the probate process?
Right. And a lot of times it depends on the assets, if there's a house or a farm or some asset that you have to sell. So it may take longer to sell. But, the shortest amount of time is 6 months, because that's the estate can't be closed until after 6 months, because there's a claims period for anybody to file a claim against the estate, and also for anybody to be able to file a will contest. And also you have to look to see, are there taxes that are going to have to be paid? Is the estate going to have to file an income tax return, a 1041? So usually about a year, and sometimes longer, just depending on when the death is, and then the assets, and then where it falls within the IRS deadline.
Interesting. So Doug, we've talked about why you would set up a revocable trust while you're living, and how it does convert to an irrevocable trust upon the passing of the owner of the assets that are going into the trust. So can you talk about why someone would just set up an irrevocable trust from the beginning? Is it because they want to freeze assets? Is it because they're afraid of getting sued? What are some reasons why they would do that? And then, or is that just not a good idea at all?
Right. So the irrevocable trust, or irrevocable trust, either way, they were set
irrevocable.
Yeah, they were set up a lot of times to save on estate tax. So when the estate tax exemption was lower, they would be set up. A lot of times they would be set up for irrevocable life insurance trust, or ILITs. And that way, because a lot of people don't realize, if you have life insurance and you can change the beneficiary, if you're making the payments, premiums, or you can make a loan against it, that's includable in your taxable estate. So back when the exemption was $600,000, if you had $1 million life insurance policy, you just 40% of that was going to go to the government in taxes. So an irrevocable trust was set up to keep it from being taxed in your estate. And then now that some people want to do that as gifts, especially since the tax exemption sunsets, and it may go back to 8 million or 16 million for a couple. So some people are making gifts to the irrevocable trust now to get that out of their estate and make those lifetime gifts. Now, the downside of that is that the irrevocable trust, their income is going to be taxed at a higher rate. So you kind of have to do some computation to see, is it better to give that property away now and pay less in estate taxes, but more in income taxes? And then also you're giving up the right to that property. I mean, you could be an income beneficiary, but you would be very restricted on what amounts you could receive from it.
So Doug, if, let's say I had $1 million piece of property, I wanted to put it in an irrevocable trust because I expect that by the time I pass away, that property is going to be worth $2 million. And let's say that the estate tax limit reverts back to that $8 million for a single person that you mentioned. Am I putting in $1 million into my lifetime giving amount, or am I putting $0 into for my estate limits?
Right. So if you transferred $1 million farm to the irrevocable trust, then you would be using $1 million of your lifetime gifts. Now, the other thing is when you transfer that trust is going to have the basis of that property is going to be whatever you paid for it. So if you paid 500,000 or if you paid $1 million, that's what's going to be the basis. So if the trust sells it, you may be looking at capital gains taxes. So there's a lot of things to look at in doing that. But yes, that would be using the $1 million exemption.
Okay. I want to say that a different way to make sure that I'm clear on that and make sure the listener, if you're transferring property into the trust, you lose the step up.
Right.
Okay. So if you pass away, say you put a house in there. So we know that houses, generally are, they are inherited at a stepped up basis. If you go into the trust with it, you lose that step up ability. Is that what I understood?
Right, because it's owned by the irrevocable trust, and the trust owns it. It's not passing by reason of death.
Okay, and then as far as an irrevocable trust, let's just say I set one up today, and I passed 1 year from now. Is there a minimum time that they have to be in force in order for them to kind of bypass the whole probate? Not bypass the probate, but to bypass being, included in the estate.
Right. That's a good question, especially in the insurance. So in insurance, if you transfer an existing insurance policy to the irrevocable trust, then you have to survive 3 years or that would be taxable in your estate. So because what they didn't want somebody to do is to, be terminally ill and transfer your insurance policy there that may have a low cash value, and then it gets a high death benefit. So there is a 3-year survivability for that.
Okay.
So Doug, I have one more question. So in that example that we put in that $1 million piece of property into the irrevocable trust, if the property is not appraised by an approved person when that property goes into the trust, how can we actually determine what the value of that property that you put in there is?
Right. So when you transfer the property to the trust, you would file a gift tax return. And so the gift tax return would need the accountant or the CPA who files that would want a certified appraisal or some value to show what it was worth. And the IRS could always challenge it. And, you could go back, even today, you could go back and say, well, what was this house worth in 1980? And they can look at the historical data and come up with, okay, this house at 325 Main Street in 1980 was worth $70,000, even though it's worth, 5 times that now. So, but to get the gift tax return, the accountant would have to have some basis for making that valuation.
Mm-hmm. Interesting. Okay. So we've talked about kind of why you would use it. What are some of the drawdowns or the reasons why you would not want to use an irrevocable trust? And, it's something as if it could be as simple as, a younger couple, they think they're going to be wealthy in the future. They're not quite sure how much money or how much their net worth is going to be in the future. Don't have an idea on estate tax limits in the future. So should they not just go ahead and put their house into an irrevocable trust, or what are kind of the drawbacks from doing that?
Yeah, so there are a lot of drawbacks in transferring to an irrevocable trust. And the main one is you can't change it or revoke it. So you don't know what situation you're going to have or, how your children are going to turn out. If you leave it to your children and, one becomes special needs or they're on government assistance, that could cause problems. Also, you may not want to leave them the money. And once you put it in there, you can't change it. So, and these really aren't used as much as they used to be. We used them a lot for the ILITs, the Irrevocable Life Insurance Trust, to use that, have a life insurance policy in there to pay for the estate tax. But since the exemption amounts are so high, unless you have the high net worth over the 16 million, or 13 million, always the number changes so much, but 13.62 million, then you don't really need to do a irrevocable life insurance trust or irrevocable trust.
So as far as I've heard a lot of things. I do a lot of research, and, we do planning for a lot of high net worth individuals. When using an irrevocable trust, so we know that when we put assets in there, we're basically giving up the control. So we would say, and I think you would probably agree with this, that if you're really young, it's kind of risky because you're going to be, putting in assets. In Richard's example that he used, put a house in there. Probably not a good idea to put the house in there just because you lose the step up in value. So I don't know that if it were me, personally, I probably wouldn't do that. But I think on the younger side, I think it becomes risky because of the loss of control. But my question really stems back to, okay, we have this irrevocable trust. We've basically given up control of the assets. Is there language within an irrevocable trust that would allow us to take a loan out of the irrevocable trust legally, since we've lost control of the asset? But can we still take a loan if there's a way to take a loan with a provision?
Yes, and that can be put in there. And a lot of times it's put in there to make a loan to the estate to pay the estate taxes. Mm-hmm. So, but yes, that could be put in there. But then the other thing to keep in mind is, it's going to pay it's going to pay the highest tax rate. It's going to be higher than your individual tax rate. So when you put assets that appreciate or they're earning income, is going to be taxed at a higher rate. So really the irrevocable trust would be best used for insurance, because that's something that isn't going to come into effect until you die. And so you're not really using that unless it's cash value. So that's usually the best use of an irrevocable trust.
So Doug, I get this question quite frequently. It's really for the clients who have, a children who is about to get married or just recently married, and they are not 100% certain that marriage is going to last. We know, as in our industry, we know that the trust is really designed for protection against creditors, debtors, and predators, and they might view that spouse that they don't like as the predator. So if they pass away and the assets flow into the trust, what protections, if any, are for the beneficiary to receive the funds and prevent the funds from being divided in the event of a divorce?
Right. So if a couple wants to say that when they die, they would like their property to go to their son or daughter in an irrevocable trust that they can only use the income from, or that that wouldn't be used to creditors, that's a way to protect that from creditors and also a divorce. Now, judges here in Alabama, they're restricted more than other states. Other states, I know in Colorado, we had a case where it was actually backwards of what I thought. An irrevocable trust could be used as income in determining alimony, and a revocable trust couldn't. But anyway, if you have an irrevocable trust and it's paying, let's just say it's going to pay the husband or the daughter $10,000 a month, then the court can look at that and say, okay, well, you have the right to this income per month, and then I'm not going to give you as much alimony. But that is a way of using it, but it's also setting it up. If you have a revocable trust and you leave it to your children, and you could say, at our death, this trust is going to be irrevocable and it's going to stay in place until my son or daughter's 50 years old or whatever.
So in the event, like, let's say the child inherits $1 million inside of a trust from the family. They get a divorce a year after they inherited those funds, but the funds are still inside the trust. Are those funds going to be divvied up?
Right. And it's going to be specific. We have a divorce attorney, and so he and I discuss this a lot of times. So the judge can always consider that as a source of income, but in Alabama, they're not supposed to use an inheritance for the property division unless they're using it. So if they take that money and they're buying a house, they're going on vacation, or they're buying cars out of it, or they're living out of the trust, then the judge can consider it. But that's the best you could do to try to protect it, to put it in a trust.
So Richard, so we just did ours. So we have a trust. And if, one of the questions I ask, and Jen was rolling her eyes, and if she listens to this episode, she'll probably punch me in the head. But I basically asked the question to the attorney, what if I die And how do I keep the money from going to Pool Boy and make sure it goes to my kids, right? And I'm serious. I asked the question, and the attorney was kind of like laughing, didn't know if she should really laugh, but it was I was kind of serious, kind of joking at the same time. So our trust, what we ultimately decided to do, I didn't want to put a Pool Boy clause in there, so I left that out. Because it makes the trust pretty complex, and there's a lot of added cost, down the road and complexity to the trust. So decided to do away with that. But our assets go into the trust and basically gets divided amongst the 3 kids, and we have their assets being held in trust up until they're 30. So they can get a little bit each year, but at 30 they can get it all. We kind of figured at 30, if you hadn't learned your lesson by 30. Then, it's on you at that point. So that's kind of what we decided to do. And we wanted to keep it a little less complex. So anyway, let's just talk about just real quick as we start to wrap up the show. And I think you touched on this, Doug, and I just want to make sure that it's clear. Irrevocable trust, we give up total control of the asset for the most part. We're giving up control. You think that pretty much the best case use, or really one of the best uses, is for life insurance that you don't want to be included in the estate. Is that what I think I heard you say?
Yes, that's correct.
Okay, well, good deal. Well, I don't have any further questions. This has been like a really good episode. I just saw Richard's hand go up. So
I got one more question, and
Sure.
This is so Doug. We have about a minute left in our episode. Just curious if you had a crazy story that you have seen in your role that you're comfortable sharing on there.
I could really tell you a lot off the off here, but I've had a lot. I don't know how I could. Well, I guess I did have one. So I was a trustee for somebody, and he was an only child. Or actually, he had a sister, but she was killed in a motorcycle wreck, and then she had no children. His parents were only children, and they left. They named a professional trustee, and there was only a house. So I was the trustee. So I told him, I said, you really need to do a will, because if not, it would go to the state of Alabama. And so one time he called up, and he was, he had substance abuse problems. So he called up and told me he needed a will. And I said, well, okay, well, who do you want to leave your property to? And he said, hold on. And he goes, what was your name again? So, but I never got her name. And so
that's hilarious. That's so funny.
Wow.
Oh, good way to end the show. Hey, Doug, we really appreciate you being here. Richard, thanks for connecting us and allowing, us to meet Doug. It's been a phenomenal conversation. I think it's been right now 56 minutes of just jam-packed information on the estate planning side. Doug, why don't you tell them if they wanted to reach out to your firm, how would they go about doing that?
All right, the best way to reach us is at 256-533-1667. Also, we're online, so we, you could look me up on our website and send a direct email to me. And we also have other ways of contacting us when you look up on the website. But I'd love to talk to people and help them out.
Yeah, so if you're in need of estate planning, please look them up. This has been a great conversation. We appreciate all the listeners. Lou Ann, Doug, Richard, thank you for all being here. I'm going to give our number out if you are in need of financial planning and want to sit down with myself and really go through your retirement situation. We'll walk through the Rite Retirement process, which includes asking questions about estate planning. We can definitely do that. You can reach us at 256-937-2010. Again, that number is 256-937-2010. Hope everybody has an awesome and blessed week, and remember to serve every person in every situation with a servant heart.
Investment advisory products and services made available through AE Wealth Management, LLC, a registered investment advisor. Insurance products are offered through the insurance business WG Insurance Services. WG Financial Group is an investment advisory practice that offers products and services through AE Wealth Management, LLC, a registered investment advisor. AEWM does not offer insurance products. Insurance products offered by WG Insurance Services are not subject to investment advisory requirements. AEWM and WG Insurance Services are not affiliated companies. Investing involves risk, including the potential loss of principal. Any references to protection, safety, or lifetime income generally refer to fixed insurance products, never securities or investments. Insurance guarantees are backed by the financial strength and claims-paying abilities of the issuing carrier. This radio show is intended for informational purposes only. It is not intended to be used as the sole basis for financial decisions, nor should it be construed as advice designed to meet the particular needs of an individual's situation. WG Financial Group is not permitted to offer, and no statement made during this show shall constitute tax or legal advice. Our firm is not affiliated with or endorsed by the U.S. government or any governmental agency. The information and opinions contained herein provided by third parties have been obtained from sources believed to be reliable, but accuracy and completeness cannot be guaranteed by WG Financial Group. This radio show is a paid placement.